I think it's troubling because I think it cuts off people's access to information about what is likely to be a trial that generates a lot of public interest. But I think more importantly, and maybe more significantly, the ban is really out of step with where communications are going, with the way in which people get their news. The adaptation of technologies by any entity often takes some time. And we're just going through that process really right now with the courts. And again, I suspect in 5 years or so, these won't be issues.
In addition to being distracting, some judges are concerned that the tweeting will actually send a message to jurors when there's testimony that's important. They'll see the reporters all suddenly starting to send tweets, and they'll say to themselves, that's important testimony. Therefore, you could argue that that somehow skews the perception of what's important among jurors.
He doesn't want you there taking, every word down from every witness, and that's why he provided an overflow room where the media is going to get live transmission of a transcript, and you could sit in that overflow room and Twitter, you could talk on a telephone, do whatever you want, but in the courtroom, he wants to maintain the dignity of the courtroom, and that's why he came up with this compromise, and it was a compromise he reached with the media in order that everybody should have their concerns addressed. And hopefully this will work out. If not, the media is going to lose the access that they have, and I don't think any news organization wants that to happen.